two cases going on at one time.
With a closed fist multiple times to the head, a stomp on her face reportedly with a boot.
I do have a history and I'm trying to work on that.
He might have an addiction to alcohol, but he has an addiction to beating people up. And in this one, you're stomping on the woman's head. Doesn't surprise me. You got drunk and violated rules, drank alcohol and went to go visit her. Stop beating people up. We're taking up people in the state of Michigan versus Jason Ford. I know we're also here for an arraignment apparently on an alleged bond violation, but I'm going to deal with that after. Of course.
Thank you. First, I want to acknowledge this is typically a rather high threshold, and that the people, I myself, did not initially score that. So I want to acknowledge that. Obviously, up to the court's discretion, but I think potentially could form a basis for the scoring. Factually, the defendant, the parties were living in a camper. The defendant returned to the camper. He appeared to be, according to the victim, he appeared to be using methamphetamine. He became confrontational, aggressive. She attempted to walk away. He then grabbed her, pulled her to the ground. She was screaming. He pulled off her shirt, her bra. She was naked from the waist up. He struck her with a closed fist multiple times to the head, stomped on her face reportedly with a boot, resulting in large abrasions. And there were marks around her neck and throat where the defendant grabbed her by the neck to attempt to get her back in the camper. In the defendant's statement on the PSI, he did acknowledge that he was in an angry rage. So I want to acknowledge that I didn't initially score it, but I also want to acknowledge what I think formed the basis for the probation department scoring. And with that, the people would leave it to the discretion of the court.
Thank you. The answer is the court finds that is excessively brutal and is also more than is necessary to normally encompass a simple domestic violence. So the answer is no. Now, this is made a felony, not because of the degree of the violence, but because of the repetitive nature and criminal convictions for prior acts of domestic violence. This is much more than a simple domestic violence. Therefore, the court denies the challenge for offense variable number 7. And Mr. Denhound, I don't think we have any, but do we have any victim impact statement to be made?
We do not.
Here in the court. Thank you. Mr. Champion, allocution.
Your Honor, my client has taken responsibility in this case. He is since entering the plea, has completed APS. He acknowledges that he has an addiction in this matter and needs to address that along with some mental health concerns. With that, I would ask the court to file the plea agreement, sentence my client to a term of incarceration with probation.
Mr. Denhound.
Thank you, Your Honor. First, I want to state that the plea agreement that was originally arrived at was arrived at with full consultation and support of the victim, Ms. Fountain. What she wanted at that time was she wanted the defendant essentially to be forced into treatment, which occurred in this case. Wanted, given the fact that the defendant had 3 prior felonies, 8 misdemeanors, and a history of assaultive conduct, I insisted that there be a felony on this case. Ultimately, based on the scoring and based upon alleged new incident, I guess I fully expect at this point that the court is not going to follow the agreement. People acknowledge that, but I wanted to explain the thought process that went into it, the input that our office had from the victim, and with that, we'll leave the ultimate sentence discretion.
It's at this time. Well, planned it this way. We're now going to turn to the bond violation allegations. Mr. Ford, this court issued a bench warrant for your arrest on November 24th of this year. The reason why it did so is that the court received information alleging that you had tested positive for the consumption of alcohol and that you had violated the no contact order by having contact with the victim, both of which allegedly occurred on November 20th. You have the right to challenge these 2 allegations at a hearing, and I can allow you due process. Nope, talk to your attorney first.
Just talk to you.
Okay. Yes, sir.
Your Honor, I take full responsibility.
Mr. Ford, it's now the opportunity that you have to make a statement to the court before I issue a sentence. Yes, sir.
Can I stand or sit?
Whatever you feel comfortable with. I know you said you weren't feeling well earlier.
Your Honor, I want to say thank you guys for the chance for me to go to rehab. I know that I did violate with the drinking and I apologize for that, but I take full responsibility and I can't take back what I did. I can't take back this crime. I can't fix it. I can say I'm sorry, but I'd rather show it. I do have a history and I'm trying to work on that. I do have I am addicted. I'm an addict. I am having a hard time with alcohol, and that's why I was asked when I do get on probation if I can be released on scram. As a condition, I'm asking that for a condition to help me. I got out of rehab and I wasn't set up right. I didn't have a sponsor. I rushed out to the world. I wasn't ready. There's no excuses. I knew what I was doing. Sorry for when the IEP meeting when Crystal was there. I'm sorry for having contact. I honestly, like I said once more, I can't take it back. No, but I am sorry, and that is my family, and I do love her. And when we did talk at the IEP meeting, I thought everything was fine. Everything everything was, we prayed together. Everything was beautiful. And I'm just hoping that I can get my family back. That's all I'm asking for. I'm asking for help with my disease.
This is a little bit about substance use disorder, but this is about the inability to control your rage and your violence. You're using substances and you have for a long time. Now, while I've had people tell me that kratom, which might be a legal substance, is okay and helps people, how come I always tend to see it in acts of violence? Well, in addition, maybe it's because it's being used in addition to alcohol and methamphetamine. Let's take a look here at the defendant's prior criminal history over the last 22 years. It began as a juvenile, started right off with drugs and violence. Then, within the year, he turns to be an adult and he starts off his adult history with larceny. Then is sentenced on July 8th, 2009. And while on probation, he commits more violence in the form of malicious destruction of property in 2010. So he already began by violating his probation. By August 9th of 2011, again, violating his probation, he is charged with weapons offense. That's concerning. And he's on probation. Again, he made it 9 months. And look at the set of charges there. And he gets it cut down to a home invasion and then firearms receiving and concealing. I'm going to suggest that those are crimes of violence, breaking into a house with intent to commit a felony inside, also have firearms. He gets sent to prison. He gets parole. 2014. He had just been out on parole, just barely commits another offense. It's not a big one, driving with a vehicle with no registration, but still, when no one's looking, he thinks he can do what he wants. And by the way, after that, still on parole, 2 months later, he's back to acts of domestic violence. While there's no plea or conviction of domestic violence, we do see interference with electronic communication devices, which we know has to do with domestic violence. And what don't you see on that charged arrest? You don't see anything dealing with drugs or alcohol. Now, maybe alcohol was involved, I don't know, but still, repetitive acts, violating probation, violating parole, repetitive acts involving violence. And then here he does have the biggest gap from 2018 to 2022 until he has some minor offenses having to do with operating vehicles when it's unlawful to do so. But that tells me when he thinks no one's watching, he'll do what he wants. He does make it another 3 years before he picks up this series of charges. One over in district court over in Wexford County. And this one, the offense date is on June 23rd. Well, barely makes it a couple weeks before he picks up one that happens here on July 10th. Got 2 domestic violence cases going on exactly the same time. And in this case, he was a fourth habitual offender enhancement. So he received a significant benefit because this case went from a potential of up to life down to up to 5 years. So this may have something to do with alcohol. And yeah, fixing it and feeling bad for somebody struggling with a substance use disorder, sure. When that results in blood, bruising, violence in front of children, upon significant others, the answer is no. And I look at his work history and it's relatively limited. 34-year-old man, a list of prior convictions, probation violations, parole violations, multiple acts of violence. I'm so surprised he doesn't have much work history. So I don't feel for the defendant as he might. I appreciate he might be dealing with this, but now the problem is now he's involving hurting other people, and that's his problem. Is it he might have an addiction to alcohol, but he has an addiction to beating people up, especially loved ones, domestic violence. So there's absolutely no doubt. I do not think this is a good deal. So I may have taken the plea, and when I do, I take those pleas. Of course, I don't know what the PSI is going to look like, but now I do. So here's a sentence of the court, and in about 2 minutes, you're going to be able to ask if the court will withdraw your plea, because I'm definitely going to. The court sentences the defendant to a $68 state minimum fee, $130 crime victims' right fund fee, $300 court cost, a $1,000 fine, $300 attorney fee. There definitely is no evasion, and the court sentences the defendant to a prison term of 30 to 60 months. Your acts of violence, your repeated acts of violence, even while you're pending, while you've got 2 cases going on at one time, and in this one, you're stomping on the woman's head. And the fact that you went and had contact with her tells me this is all about your arrogance and control and manipulation. That's what domestic violence is all about. Doesn't surprise me. You got drunk and violated rules, drank alcohol and went to go visit her. It's all a part of your control. And the fact that she supports this deal has 0 impact on me. I expect her to. When I was a prosecutor, every single domestic violence case, the woman showed up at my office and would tell me how bad and evil I was, that I was prosecuting her loved one. And I would smile. When I smile, but I would tell her, I appreciate your conduct and attitude, but I'm here to defend you when you can't defend yourself. Those requests to let the person out, not give them jail, dismiss the charges, never once. And here you focused on you and alcohol. I don't care anymore. Stop beating people up. That's the sentence of the court. Mr. Champion, as you know, your defendant now has the right to withdraw his plea because I busted the deal because the deal was for a limit at 1 year.
Yes, Your Honor, my client at this time would move to withdraw his plea.
All right, the court hereby grants that request to withdraw the plea. It's withdrawn. The defendant's bond is revoked. He's remanded into custody. Thank you very much.